seats. We're going to start up. It's 9:03. We're just going to take a minute and let you get your amendments up. And then we'll go through and see who's here. Hey, I've got a call from Representative Henderson. He's stuck in traffic, but he will be here. I see no reason. I don't know who's on WebEx, so if the IT person would tell us who we have on WebEx this morning.
Jordan Mahallahan, Matt Sterling, Michelle Segan.
Okay. No members. Thank you. Because of the large number of amendments, we're going to do this just a little different than we on a normal bill. I'm going to take the amendments up first, and then I will see what gets on, what does not get on. And then I've talked to the reviser. He will need some time to reconcile all of the amendments. And then at some point in time when they are reconciled, I will open up the original bill of 2184 and would ask for a motion to put in all the amendments that's been approved. And then if there's the consensus of the committee, I would ask for a motion to pass it out. So I have asked leadership about next week. I think that I can get at least one day, possibly two. But the second day may be more difficult because we're going to be on the floor, as you all know, next week. If they one day decide to go in the floor at 11, then we will have that opportunity to come back in here, further discuss that. But I understand by talking to the members who are bringing these amendments, there has been agreement in many areas, and that's what we want. We would like to have, as much of an agreement on the amendments as we can get. So with that, I'm going to turn to Representative Carpenter. You have two large amendments, is that correct?
Yes, Mr. Chairman.
Which one would you want to go through first?
Carpenter One, Mr. Chairman.
Would that the one that would start on page 3, and the first amendment would be Space Force, just adding in Space Force?
Yes, Mr. Chairman.
Thank you. If members, if you could be so kind as to look in your file, hook up what I have listed as Carpenter's One, starts on page 3 of the original bill. And let me get a pen that writes. Would you like to have the reviser go over it first, or do you wish to go over it first?
I'll leave it to the reviser, and I'll make any necessary comments, Mr. Chairman.
Thank you. Matt, do you have what is called Carpenter's Amendment 1, which starts on page 3, and the first change is adding in Space Force to any state?
Yes, Mr. Chairman. Thank you. To recap, I'll run through this quickly. The first change on page 3 has been addressed. Is just going to add clarifying information on the definition of veteran. The next changes are on page 5 of the bill, requiring a vacancy in the advisory committee to be filled within 21 days, and requiring the advisory committee to provide a report to the legislature every year on recommended changes to the act. The next change would strike section 16, the reciprocity agreement, the state reciprocity agreement. The next change on page 14 would require that if the committee had not made a recommendation on a submission within 6 months, the submission would automatically be denied. Then there would be the insertion of additional language in section 20 and 21. Those would be the attachment 1 would pertain to those requirements for licensure that were modeled after the existing requirements in 41.311 for licensure under the Liquor Control Act. It has many of the same provisions. Not included in this is, as Representative Carpenter referred to, the 3-tier system. And then also there is the additional requirement in paragraph 3 requiring a certain level of residency requirements for ownership in a licensee that are in the state of Kansas. The other new section would be the advertising section. Has a number of requirements for advertising for medical marijuana. The only thing I would add to that is consistent with the intent of Representative Carpenter's original amendment. I've clarified the language in this last subsection pertaining to advertising for medical marijuana so that the sale of medical marijuana could not be advertised by an entity. They could not make that price list available. They'd be able to make a price list available, but they cannot advertise for the sale. And then it would be prohibited on any billboard that was located along a state highway. Coming back to the changes to the bill, there's the additional requirement that a petition that was recommended for denial by the director would be able to be resubmitted after 24 months had elapsed. There's the additional requirement that if a dispensary knowingly disclosed patient information to any individual, the director would impose a civil fine of $5,000 and revoke the licensee's license. And then additional clarification on the use of marijuana in the act to clarify it's referring to medical marijuana. And that's a quick run through. Happy to answer questions about the Carpenter One Amendment.
Thank you, Representative Carpenter. I understand by agreement of the others that are bringing amendment. Is there any areas in this one where there's any compromise?
There was, Mr. Chairman. Thank you for the question. After, I would say, a long conversation amongst myself and the other bringers of amendments, one modification that I would make to this first amendment, I was striking new section 16, which was dealing with reciprocity licenses. That is located on page 10. I'm willing to leave that language in at this time, Mr. Chairman.
Thank you. Folks, what I'm going to do is I'm going to go through page 1, page 2, page 3 with the different changes. And if you have an objection to that section, please list it. I'll check it off. We'll come back to it. And then we'll go to 2. And then take those issues up where there's an objection been made. And we'll come back and I'll probably ask for a vote on those. So, as to page 3, which is the first page. Well, let me ask you, Representative Carpenter, do you have any other arguments that you'd like to?
I'll address any questions or concerns at the appropriate time.
Thank you. On page 3 of the Carpenter First Amendment, is there any objection to adding Space Forces? It's, it's a new service. It was probably overlooked when they drafted the bill, and it's the Army National Guard. So they're just adding on the Space Forces. Any objection to that portion? Yes. I'm sorry? Objecting, okay. Okay. We'll come back to that. Page 5 of the amendment comes down to a vacancy being filled within 21 days of such vacancy. Is there an objection to that? Seeing none. You check behind me. Okay. And then the second change would be prior to January 1st of each year, the Medical Marijuana Advisory Committee shall provide a report to the legislature concerning any concerns with or recommended changes to the medical marijuana. Any objections to that portion? Representative Jacobs?
Mr. Chair, no objection, just question.
All right, go ahead. Ask your question.
Thank you, sir. To the revisor of the carrier, please. On that second balloon, who would make up that advisory committee?
Could you use the microphone a little?
Yes, sir. On that second balloon, who would make up that advisory committee?
Mr. Chair, I can answer this. Just give me a few seconds to pull up the bill unless Matt can beat me to it.
I'm happy to jump in if you'd like me to, Representative.
I got it. Thank you, Representative, for the question. Under new Section 5, which appears on page 4 of the bill, 8 members will be appointed by the governor as follows: 2 members who are practicing pharmacists, at least 1 whom supports the use of medical marijuana, at least 1 whom is a member of the State Board of Pharmacy, 2 members who are practicing physicians, at least 1 of whom supports the use of medical marijuana, and at least 1 of whom is a member of the Board of Healing Arts, 1 member who represents employers, 1 member who represents agriculture, 1 member who represents persons involved in the treatment of alcohol and drug addiction, 1 member who engages in academic research on the use and regulations of medical marijuana, 2 members appointed by the President of the Senate as follows: 1 member who represents law enforcement, 1 member who represents caregivers, 1 member who is a nurse appointed by the Minority Leader of the Senate, 2 members appointed by the Speaker of the House, and they are as follows: 1 member who represents persons involved in mental health treatment, 1 person who represents patients, 1 member who represents employees appointed by the Minority Leader of the House of Representatives, and the Secretary of Health and Environment, who shall serve as the chairperson.
Thank you, Mr. Chair.
Thank you. There's no objection to this, please. Thank you. As to the striking of Section 16, my understanding from the representative, he's not objecting. He does not going to strike that portion.
Mr. Chair, my proposal is, yeah, that is correct, not striking that portion at this current point in time.
Thank you. Let's go to page 14. The changes there: if the committee has not made a recommendation on a submission within 6 months, the submission shall automatically be recommended to the Secretary for denial. Would you just make a few comments about these 3?
Yes, Mr. Chairman, I can do that. Basically, my thought process is that I did not want, for the first balloon amendment on page 14, I did not want a person to ask for or submit a new proposal to the committee and then it just languish for long periods of time. I wanted to have at least an answer for whoever was seeking such an item to be recognized. And so that would be within 6 months. So if after 6 months have elapsed, it would be sent to the Secretary for denial at that current point in time. And then for attachment 1 and attachment 2, attachment 1 is, as the revisor stated, he borrowed very heavily from the Connecticut law on advertising. And then I did add 1 tweak to the end of the attachment 1, which is in regards to prohibiting billboards along state highways. As far as attachment 2, that is in regards to bringing over our current licensing requirements for liquor licenses that we use here in the state of Kansas. My logic or reasoning behind that is because both of these items are controlled substances. Alcohol and marijuana are both controlled substances, and I did not want to lead that to rules and regulations as the bill currently has it. So I felt that that was a good baseline for us to start at, and then I did tweak our alcohol licensing items in Amendment 2. I took out the 3-tier system and wanted to have that, we could have that as a separate debate, and then also added the 75% residency requirement for the licenses. And so those are what those 2 3 major balloons are doing on page 14.
Thank you. Is there some agreement between you and the other makers of amendments? Have you agreement on that?
Mr. Chairman, as far as I know, no one has indicated to me that these are bad amendments, but I'm willing to take questions or concerns.
Yes, Representative Garber.
Thank you, Mr. Chairman. ASA 5626 is the Kansas Consumer Protection Act. Is anything added to that act under this amendment?
I have to refer to the revisor.
Matt, if you could answer that question.
Thank you, Mr. Chairman. There was no change under this made to the Consumer Protection Act. If that's something the committee's interested in, we could explore that as well.
I ask that because the Consumer Protection Act specifically prohibits deceptive acts and practices, exaggeration, falsehood, innuendo, or ambiguity, failure to state a material fact, disparaging the property, services, or businesses of another, false or misleading representations. I would think the Kansas Consumer Protection Act would basically cover most, if not all of the stuff in this attachment.
Helpful. Any objections to page 14? Yes, Representative Heiberger.
I've got some concerns about the first paragraph. I mean, it essentially gives the committee a pocket veto. If they fail to act, then they denied. I mean, if we're going to keep something like that, I'd rather have it say if they don't act within 6 months, it's automatically recommended for approval.
Thank you. You wish to respond?
Are we going to come back and debate?
No, we're going to
these
come
items?
back to it. I'm just going to put it down that section 1 is you're talking about, correct, Representative Heiberger? Thank you. I'll put that down as an objection. Come back to it. Okay. No other objections on the other sections? Thank you. I'm sorry?
Back to this, is that what you're saying?
Yes, sir. Yeah, I'm just trying to see what the points that we need to discuss. On page 18, that the applicant is not disqualified from holding a license pursuant to section 21 and amended thereto. You have some comment there?
Over the next several pages, Mr. Chairman, you'll see the similar balloon amendment on those items. That is because if attachment 2 were to go on, it would remove the provisions that are in the bill because we are defining what the licensing standards are instead of leaving it to rules and regulations. And so that is why you see the license pursuant to section 21 earlier in the bill. So that's all this is doing, is just cleaning that up and making it to where it points to attachment 2.
Thank you. Any objections to that portion? Seeing none. Going to page 20. Representative?
Next page is page 24, Mr. Chairman, for any substantial changes. Over the next several pages, it's all the same change.
Same page. All right, thank you. What about page 23? Any petition that is recommended for denial by the director? Is that all included?
Yes, sorry, apologies. I missed 23.
Right.
Page 23, basically I'm adding this amendment because right now, according to the bill language, it says the secretary's decision is final on if somebody were to petition for the form or method of using medical marijuana described in the petition. The problem that I have with that is that with the way this is written, the secretary's decision is final. That in my mind means in perpetuity. And I wanted to provide a mechanism here to where people could still petition and come back at a later date and time if there's more scientific research or what have you on a method or form for using medical marijuana.
And that time period would be 24 months.
Currently, that time period in the bill is 20, or in my amendment is 24 months. Yes, Mr. Chairman.
Thank you. Any objections to that section? Yes, Representative Garber. I'm just going to mark it down. We'll come back to it. Go to 24, I believe now.
Yes, Mr. Chairman. So on 24, basically, I'm adding it to where somebody has to knowingly disclose patient information. And as we heard on the floor the other day, there was knowingly, intentionally, and recklessly. Knowingly is the second standard within that criminal statute. And so they actually have to, my understanding is there's a lot more attorneys and judges here on this committee that can describe this better than I can, but they actually have to go out of their way to break the law, is my understanding with knowingly. So if they go out of their way, break the law, give over patient information to unauthorized people, then that would be a $5,000 fine and the license would be revoked.
But this is just a civil fine.
Yes, that's my understanding. It's a
And
civil
that
fine.
would be determined by the secretary?
The civil fine would be imposed by, I'll have to ask the revisor just to make sure that it's not, I think it's the director, but
Director of ABC.
Thank you, Director of ABC. Just wanted that clarification. Any objections to that portion? Very well. Moving right along to page 25, you have struck, I believe, A, B, and C.
I believe that that is going back to the new section 21 dealing with licenses, if the revisor would like to correct me or not.
That's correct.
And then the last item is just inserting the word medical in front of marijuana on page 28.
Any objections to that? Seeing none? That's all the parts on this First Amendment.
Yes, sir.
I'm going to go back to the first objection, which is the adding of space forces, I believe, Representative Heiberger.
Yeah, I guess I don't have a strong feeling about this, but as far as I can tell, well, there aren't any veterans of the Space Force in Kansas at this time, or if there were, I'd be surprised. And it appears, I'd rather see if this division actually lasts before we clutter up our statute books.
Thank you.
Thank you, Mr. Chairman. Well, right now, there are members who have transferred into the Space Force from active duty branches. There are currently people who are now serving in the Space Force. As far as how many of those individuals are serving here in the state of Kansas, I do not have that at this time. However, if somebody were to serve in the Space Force and then want to seek to retire or come to Kansas after their service, I think that this is should still be an option. We're not just focusing on the here and now. This is obviously legislation that will take us out for years to come. So I think that we need to try to make sure that we cover all the current military branches that are recognized by the federal government at this time.
As of, what, a couple of years ago, I guess it is a military branch, although it is a department of the Air Force, just like the Marine Corps is a department of the Navy. But I have other comments, yes.
And thank you, Mr. Chairman. I was wondering, for the carrier of the amendment, would it be amenable, appropriate to just change it to general language, saying having served in any of the uniformed services of the United States? And just catch all.
Actually, I was getting ready to withdraw my objection.
You withdraw your objection. Thank you. You've withdrawn the objection. Okay, so we're assuming that's going to be part of it. Moving to, there is no objections that I have on page 5. Was there an objection on page 10? This is where he reinstated his reciprocity. Yes, I'm sorry.
Thank you, Mr. Chairman. I guess I stepped out for a minute while this was being discussed. Yeah, I simply object to this. I mean, I'm opposed to the bill, so I guess it wouldn't be much of a surprise that I object to this, to Section 16.
The reciprocity?
Yes, sir.
Okay. I don't know if you were here or not. It's been indicated to me that he struck it in this, but he's not going to, he does not want to strike it in the bill. That be correct, Representative?
Mr. Chairman, so my stance has changed on the new Section 16. Originally, when I wrote this amendment, I struck it. However, I would prefer to have the Rules and Regulations Authority go in and determine which states have the same standard as us or above us. There's another amendment that has been introduced that would allow for complete, true reciprocity to where we don't even have that standard in place. And we just recognize all 50 states, if everybody wants to allow marijuana or what have you with their residents, we would have to accept that. I would prefer to have this language in there versus the other language in another amendment. And so that is the reason why I've made the compromise that I've made, is because, in my opinion, this is better language than opening it up, true reciprocity, and not having any standards. Thank you, Mr. Chairman.
Thank you. Was that helpful, Representative?
I think I understand the intention of the maker of the motion, Mr. Chairman.
Do you still have an objection?
Yes.
Okay. I have a question. You don't have to answer it, but you've indicated that you're not for the bill. Are you going to object to every section?
No, sir.
Oh, okay. Just want to make sure. Okay. So that's one that we will. Representative Carpenter, you've indicated there's another amendment with other language on the reciprocity that will be brought.
Yes, Mr. Chairman, and I oppose that other language, which is why I am attempting to add the new Section 16 back in on my amendment instead of striking it.
Thank you. All right. Okay. Let's go to page 14. There was an objection on that page, and my error, I should have wrote the name down. Representative Heiberger, you object?
I basically stated my objection for it. This basically gives the committee a pocket veto. If they just fail to act, then the submission is denied. And we earlier put in a provision requiring action for appointing board members if no action is taken. I think rather than just giving the committee the pocket veto, if we're going to keep this, I'd rather have it be automatically recommended for approval.
Okay. So that would be an area. You wish to respond?
I would encourage debate on that from the committee. I can understand and see where the representative is coming from. I would still prefer denial, but I'm not going to,
Okay.
I would leave that to the committee.
All right. But that's an area that we will need to vote on. Page 18, that the applicant is not disqualified from holding a license pursuant to Section 21 and amended thereto. Is there an objection to that section? Seeing none, moving right along. Page 20, that the applicant is not disqualified. That's the same objection on the next 3 pages. Thank you. I have no objections on that. Moving to page 23, I believe, yes. Any petition that is recommended for denial by the director shall not be resubmitted until 24 months with an elapse. The petition was submitted. I had an objection onto that. Was that you, Representative Garber?
Yeah. Okay. Mr. Chairman. Representative, is there any reason why you selected 24 months?
I think we discussed this yesterday during our meeting. I'm amenable to 12 months, but I wanted some time to elapse after a decision has been made because I don't want people continuing to file frivolous petitions and taking up and absorbing the secretary's time. And so the hope is just like in this committee, if we take up an amendment, we don't take up the exact same amendment the same day because it's frivolous. And so at that point, I wanted some time to pass so that if there is any other scientific research that is done on the form or method of using medical marijuana, then the potential for a change in the secretary's decision has had time to happen.
Do you have a suggestion?
Just a second.
Oh, I'm sorry.
I'm not done. Sorry, Chairman. Would you be opposed to putting some language in there that leaves it to the discretion of the secretary? How much time should pass? My questioning is, if something does change, and maybe it's just a minor infraction as opposed to some other reason why he was denied, the person was denied, should we leave it up to the secretary's decision?
I'll leave that up to the will of this committee. I guess I don't see any problem if they decide to change their mind. However, what I want to prevent is confusion. So if they deny it and then next thing you know they turn around and then accept it, I mean, thank you.
What I would propose, when I take up this section, Representative Carpenter will make a motion. If you may want to make a substitute motion and change that amount of time, then we'll have the debate at that time. Would that be agreeable? Thank you. Page 24, there was an objection. Representative Garver?
Thank you, Mr. Chairman. Representative, wouldn't this language that you're imposing, wouldn't this be covered under HIPAA?
As of right now, I think if somebody were to violate someone's HIPAA rights, I don't think, with the way the bill's written, that they would lose their license. But if I could ask the revisor, Mr. Chairman.
Matt?
Thank you, Mr. Chairman. I would interpret this amendment as addressing a different issue than the Kansas Consumer Protection Act. This would be allowing the director to impose a civil fine and revoke a license for the actions of a licensee. So while there may be some protection under the Kansas Consumer Protection Act, this would be a specific authorization for the director to take action against a licensee.
Is that helpful? Yes.
So, Matt, I guess under the Consumer Protection Act, I understand, but is that, I think I'm okay. Thank you.
Thank you. Is that a continuing objection? Representative Garber?
Yes, I'm done.
That's an area that we'll need to vote on?
Again?
So that is you have a continuing objection, so is that an area that we need to vote on?
And we're dividing the amendment. We're going to vote on each one separate.
A lot of these we are. It's the only way we can get through this.
I think it's okay.
You won't raise it? All right, the objection's raised. Moving right along, we have paragraph 25, where you're striking subject to paragraph C. Is that just, go ahead.
That was just licensing.
Right, that's what I thought it was. Any objections to page 28, where he inserts medical for marijuana? Objections noted. I think that concludes this amendment. Would that be correct?
Yes, Mr. Chairman. According to my notes, we will have to debate and vote on page 10, new section 16, whether the reciprocity language is struck. Also on page 14, on whether or not there's a 6-month period where they have to approve such a condition or it's an automatic denial.
That is my understanding. Start with page 10. Your motion would be to leave that section in, correct?
Yes, Mr. Chairman, because I believe it's better than the alternative.
Thank you. I have a motion to leave section in that was previously struck by the amendment. Is there a second? Second, Representative Howe. You wish to close?
Is there any debate or any questions?
I didn't have any questions.
Okay. Thank you, Mr. Chairman. Well, actually, there's...
Somebody behind me?
I just want to be clear, when we vote here, we're voting to restore the section. Is that correct?
That is correct.
Thank you.
Thank you.
Yes. Mr. Chairman, I think that the standard of having our standard should be that a state should be equal to our standards or better than. And that is what this section will provide for. And that is the reason why that's the reason why I'm making the change and adding that language back in. With that, Mr. Chair, I move my motion.
Thank you. Further discussion? All in favor on restoring new section 15 that was struck in the Carpenter First Amendment, say aye. Those opposed, no. Opinion of the chair, the ayes have it. Ayes do have it. That's, Matt, did you get that? That would be reinstated?
Yes, Mr. Chairman.
Thank you. I think the next one was on page 14. Would that be correct?
Yes.
That was Representative Heiberger's objection.
Again,
I'm sorry?
Can I go through, address it again? I've spoken to it twice, but I can go through it again if you want.
No, but that was your objection.
Yes.
Right. Further discussion on this portion? Seeing none, Representative, you may do your motion. You may.
I guess I would move that the proposed top balloon on page 14 be changed so that it says, shall automatically be recommended to the Secretary for approval rather than denial.
All right, so that would be a substitute motion? I have a motion made.
Yes.
Thank you. Okay. Representative, do you wish to make a motion to approve?
No, I think at this point in time, I'm going to vote no on that. I appreciate the representative's insight, but at this point in time, I'm still going to stick with denial, Mr. Chairman. Thank you.
I guess I've got to go back for housekeeping. You've made a motion to pass it, correct? I didn't believe you had, so.
I don't know if there was an original motion to pass out the entire thing, no.
No, I understand it, but just page 14.
Just page 14, specifically the top balloon, there was no motion. He made a motion to substitute what I already had in my amendment.
Okay, it wasn't a substitute motion, it was an original.
Okay, it was an original motion. Sorry, Mr. Chairman.
Thank you. Very well. As to Representative Heiberger's motion to strike denial and add approve on page 14, is there a second? Representative Reese has seconded it. Further discussion on the motion? Seeing none, all in favor say aye. Those opposed, no? Opinion of the chair, the noes have it. Noes do have it. It remains as denial. Representative, would you make a motion to approve that section on page 14, all three?
Thank you, Mr. Chair. I make the motion to pass those items as written.
Thank you. Do I have a second? Representative Arnberger has seconded. Discussion on this portion of it? Yes?
One clarification, is this motion for just the first item or for all three items?
I was doing them all together.
All right, thanks.
You have a question?
I have a discussion. Thank you, Mr. Chair. I just want to state that in new section 20, which I believe is the advertising amendment number 1, I went to Oklahoma City a couple weeks ago, and on my drive down in Oklahoma, all I saw were billboards advertising medical marijuana. And one of the billboards that just really caught my eye was a picture of a guy, and it said, "Want medical marijuana? Call this guy." And it had a phone number, and I don't want that in Kansas, so I'm glad that you brought this amendment. Thank you.
Thank you. Further discussion on the motion? Yes, Representative Garber.
Thank you, Mr. Chairman. Am I under the understanding we're just discussing the advertising portion, section 20, attachment 1?
No, I was looking at all three on page 14.
Okay. Section 21, attachment 2, I have a question for the carrier of the amendment.
Yes.
Are other addictive prescription drugs treated the way we're treating this in Amendment 2, Attachment 2?
Thank you, Representative. Well, I would argue that if this was like other drugs, it would be in pharmacies. However, we're creating dispensaries with licenses, and so we can't treat it like we treat everything else, because if we were going to do that, then it'd be in a pharmacy and not how we're currently describing it. So I would say that it is very similar in how we treat our other controlled substance, which is alcohol, here in the state of Kansas, which some could argue is an addictive substance as well. And so since we regulate alcohol, which is an addictive substance, I felt like, this would be a standard that we could put into this legislation without leaving it to rules and regs. And that's basically what I was doing, trying to put the minimum standard into what it would require for somebody to obtain one of these licenses.
Okay, well, I'm going going to argue that because if we compare it to alcohol, alcohol, in my opinion, does nothing good for anybody. You know, it destroys the liver and the kidneys. I mean, I don't care if you drink it, I drink it too, but we are talking about a substance at this point that has been shown time and time again to help hundreds and hundreds of people's lives and change them for the better. And I just don't think that this is a good amendment, so I will not be supporting it. And the other question is, you had in this amendment, this attachment, I believe, that no dispensary can be owned by a corporation.
I will have to refer to the revisor because the revisor has dug into the corporation language that we actually have, and it's the same language that we have in our alcohol laws as well.
Matt, if you would.
Thank you, Mr. Chairman. So that reference is lifted from the provisions in 41.311, and that's just indicative of that the actual licensee needs to be a physical person, that if there are violations committed by that licensee, it's an individual that can be prosecuted as opposed to an entity.
So, am I understanding you to say that a corporation a dispensary can be owned by a corporation?
The licensee has to be an individual, but that individual licensee can be part of a corporation that operates the facility. But the licensee would have to be an individual.
Let me give you, for instance, I am a sole owner of a corporation. Can I get a license if I so desire?
Yes, an individual would have to get the license, and then the dispensary can be operated. It can be operated by a corporation, but the individual has to be the licensee.
Okay, thank you.
Was that helpful? Was that helpful, Representative?
Again?
Was that helpful?
Yes, sir.
Thank you.
Thank you.
All right. I have a motion. I'm sorry. Oh, Representative Smith, I'm sorry.
It's all right.
You got my back.
Chair.
I never see you.
I need to get that poker. I know I do. So I just want to make the comment on tail end with Tory there. I'm sorry, Representative Barnberger, on reference to advertising. We don't need to pretend that this is the same as alcohol. We don't need to pretend also that it's the same as hydrocodone, which has helped millions of people. When we're trying to decide these things, we need to figure out, what exactly you want up on those billboards. You wouldn't want a guy saying, hey, if you need hydrocodone, call me. And so we don't do that. And we need to control this a little bit. My main comment is trying to compare it exactly apples to apples is not going to happen. It's not going to work for us. We're always going to have an argument on the other side of it if we do. So just want to make that comment.
Thank you. Representative Wagner.
Thank you, Mr. Chairman. Representative, under the advertising section on billboards, it says billboards located along a state highway. So are federal highways included in that, or is that a specific just state of Kansas highway?
Representative, I don't believe there are any federal highways. Those are all maintained and operated by the state of Kansas.
So
Is my understanding. So even though it's like Interstate 70, that's maintained and that's a state highway.
okay, just the legal definition.
Unless the revisor would like to correct me.
Nope.
On top of that, but as far as county roads, there would be no ban on billboards along county highways.
That is correct. This is just in regards to state highways.
Okay. I mean, I speak in reference in Reno County. It's a county road that takes you down from Hutchinson down to Yoder, which is the way that everybody goes to Wichita. Heavily trafficked. It has multiple billboards. I mean, it can be something solved later, but county roads would be something that could be a problem.
If I may respond. Thank you, Mr. Chairman. You know, I'm very familiar with that area because I grew up there, and I'm sure that the Amish folks of Yoder might have a thing to say about to their county commissioner or others who own that land. So I'm sure that they would probably want to talk to their neighbors before erecting such billboards in that area. Thank you, Representative.
Thank you. Yes, Representative Howe.
Thank you, Mr. Chairman. I think this is a responsible part of the amendment. I will support it. I think it's important for the committee to be reminded that marijuana is a controlled substance under the Controlled Substance Act. It's on the schedule with heroin, LSD, and methamphetamine. So I don't think you want any of that on a billboard, do you? Thank you.
Thank you, sir. Further discussion? Yes, Reverend Garver.
I recognize the fact that marijuana is a controlled substance. However, how do we rectify the fact that some surveys of law enforcement officers have nearly a 70% approval rating for medical marijuana? So we've got a conflict here, obviously.
I would agree there is a conflict. I know there's, 30-some states that have it, and it is against the federal law. I know the Department of Justice is not spending any money to enforce it. And I would imagine at some point in time, the United States Congress, who never acts, may actually act in this instant. But with that said, I have a motion in front of me for the discussion. Seeing none, yes, Representative.
If I may close.
You may close.
Thank you, Mr. Chairman. Committee, this is, I think, a common sense proposal with the licensing and with the advertising items in here. I mean, for instance, with the licensing, you have to be a citizen of the United States. I think that's a pretty common sense deal. You also can't have a felony under our laws or any other laws, and nor can your spouse, in order to own a dispensary. So I think that these are just common sense steps that we can put into this bill now that we're not going to leave to rules and regs. Mr. Chair, with that, I move my motion.
Thank you. As to the motion to approve the amendments that are listed on page 14 of the Carpenter One Amendment, all in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. Matt, that has been approved. Moving to page 18. That the applicant is not disqualified from holding a license pursuant to section 21 and amended thereto. You're striking A and
That's in regard to the licensing
Yes.
items that we just passed. So I don't know if we really want to consider that.
yeah, we've just taken care of that. Thank you for bringing that to my attention. Is that also true in section page 20? We're going to 21.
My understanding is that the next amendment that is an actual amendment would be 23, page 23, because
You're correct.
the other amendments were just cleanup based on what we just.
23, and there was an objection by Representative Garver. Any petition that is recommended for denial by the director shall not be resubmitted for 24 months. I think there's some leadway here. You've indicated that. Representative Garver, what number of months are you looking at?
I would be satisfied with 12 months if I can make a substitute motion to change 24 to 12.
Representative?
Thank you, Mr. Chairman. I see that as a friendly motion.
Well, I've got to have a motion first to pass it out before I get, you can just make a motion to change it from 24 to 12.
I move that we change the balloon amendment that from 24 months to 12 months.
Thank you. Is there a second by Representative Carpenter on that? Thank you. I have a motion and a second to change, I'm sorry? The second was Representative Carpenter. To change it from 24 months to 12 months. Do you have that, Matt?
Yes, Mr. Chairman, I do.
Thank you. Further discussion on moving it from 24 months to 12 months? Any discussion?
Mr. Chairman? Thank you, sir. Just a quick question. The amount of time that it would take said information to come in, data to be scoured and recommended and acted upon, is 12 months enough time for that to happen? I'm in favor of the 24.
Was that just a statement or a question?
That was a question for either of the carriers, for either the substitute or the original.
So restate your question again.
Given 12 months, is that enough time to actually have any petition, to actually have data come in, have it go to the director for consideration appropriately? Can they do that and turn around in 12-month time, or is 24 more appropriate?
Well, my comment would be the state government is slow, but I don't think it's that slow. I'm sorry? True. I'll let either one of you. Yes, Reverend Garber.
Yes, thank you, Mr. Chairman and Representative. I believe 12 months is plenty of time. I would have liked to have had it at the Secretary's discretion, but I understand we don't want to tie him up that much either. So I would be satisfied with 12 months, and I think it's sufficient time.
Thank you. Any further discussion?
Mr. Chair,
Yes.
I think that's
I'm
probably.
glad you don't have that poker.
It's coming. I believe, though, that what this is saying is after it's denied. So you're not really waiting to analyze. It's already been analyzed and decided, right? So the 12 months comes after. So this is simply to wait for the next submission, 12 months.
Thank you. Further discussion? Reverend Weigler.
Thank you, Mr. Chairman. If you look in section 19, where original applications for petitions, for qualifying medical conditions, it is a pretty thorough process. I would think that if the committee had rejected a condition, that serious reconsideration would wait upon new scientific evidence that would somehow develop. I think the 24 months is really much more appropriate, given the in-depthness, if you look at section 19 of the original application.
Thank you. Okay. Seeing no further discussion, Representative Garvey, you may move your motion to amend from 24 to 12 months.
Thank you, Mr. Chairman. I move my motion.
Thank you. You've heard the motion of Representative Garver to amend Representative Carpenter's amendment from 24 months to 12 months. All in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it. Division has been called for. All in favor of amending from 24 months to 12 months, raise your right hand. 12. All in favor or not in favor of the motion, raise their right hand. 9 to 11. 12 to 9. The 12 to 9, just want to get from both. I always have two people count. The motion passes. Moving right along. Again, we had an objection on page 24.
Mr. Chairman, that objection was waived.
It was waived. Thank you. It was. So I'll let you move your motion.
Mr. Chairman, since there's nothing else in here that was objected to, can I go ahead and just move the whole packet at this point of what we've agreed to?
I think it would be appropriate.
Thank you, Mr. Chairman. Mr. Chairman, I move that we pass Carpenter One Amendment favorably.
I have a motion to pass Carpenter One favorably. That would be with the, as amended.
As amended.
Thank you. Ben, will second that. Further discussion? All in favor, say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes have it. The Carpenter Amendment 1 is passed out as amended. Going to move to Carpenter 2. Do you wish to have the reviser?
Yes, Mr. Chairman, if the reviser would.
Matt, if you would go through Carpenter 2, which starts on page 6.
Thank you, Mr. Chairman. Okay, starting on page 6, the provision that pertains to gifts or gratuities given to agencies regulating the act. Violation of that would be under the bill is a misdemeanor, punishable by $500 or up to 6 months in prison. The bill would change it to the amendment would change it to a level 7 non-person felony. Going to page 8, it amends section 9 pertaining to KDHE assigning a ID number for every registered patient, would add requirement that that ID number would be part of an electronically scannable ID card, and that upon scanning the ID card, it would provide a dispensary with verification from the department that a patient or caregiver had a valid registration. Page 11 and 12 pertain to the physician-patient relationship. It would reduce that from 12 months to 6 months. On this first page, it pertains to the original language in the Carpenter 2 Amendment, allowing exceptions from that 6-month requirement if a patient has moved from out of state, if they currently had a recommendation from a provider or from a physician but no longer had a relationship with that physician, or if they were a veteran for that original recommendation. And then on page 12 includes the additional information originally from the Epley Amendment pertaining to requirements for the physician to review medical records, that all the information be reported to KTRAX. And then for a patient that had previously had a medical marijuana recommendation, they would have to maintain that physician-patient relationship for 6 months before they could go to a new physician to get a recommendation. Moving to page 16, this pertains to the fees for a cultivator license. It strikes the original language and inserts a uniform requirement of $20,000 for the application or renewal, with $18,000 of that being refundable if the application was denied. And then it would have an annual license fee of $20,000 for up to 500 plants, and then an additional $2,000 for each 50 up to 1,000, and then an additional $2,500 for each additional 50 above 1,000, with a max of 1,750, with the exception that a licensee could apply to the director for an additional 500 plants annually. As Representative Carpenter indicated, the total if you total all that up to 1,750, it ends up being just under $100,000 of an annual license. Page 22 would provide a board of county commissioners the ability to adopt a resolution prohibiting dispensaries in that county. Page 25 would set a cap on all of the number of licenses in the bill at 10 cultivator licenses, 5 labs, 10 distributors and processors each, and then 60 dispensary licenses. Oops, sorry. New section 47 would basically rename the Division of Alcoholic Beverage Control to the Division of Alcohol and Marijuana Control. Page 39 would provide that an individual who is not a resident of the state and that was temporarily in the state, whose acquisition and possession of medical marijuana was in conformity with the laws of their state of residency, would not be in violation of criminal possession of marijuana while in Kansas. And that's a quick run through. Happy to try to answer questions.
Thank you. Questions for the reviser? Yes.
Thank you, Mr. Chair. Matt, I'm looking on page 16 when we're talking about the licenses. I don't see that in the amendment we're talking about level 1 or level 2. I'm just curious, is that anywhere else in the bill where we're talking about the different levels?
Thank you. So, yeah, the bill breaks out level ones and level twos by size of or the number of square footage that the licensee uses. There is another reference to it, so if this was adopted, I would just be removing that. That's part of one of the many things of cleanup that would be done based on the adoption of balloons that the committee makes. But this amendment would make it a uniform license as opposed to splitting it out between a level 1 and a level 2 cultivator license.
We go through the pages now, if that's agreeable. As to page 6 on the Carpenter 2 amendment, moving it from a misdemeanor to a level 7 non-person, I would tell you that's a presumptive probation level. Of course, it's based upon your criminal history. Yes, Representative Heiberger.
I'm objecting.
You're objecting? Yes. Okay. Any other objections to that? Seeing none. Go to page 8. Representative, you want to just...
Yes, thank you, Mr. Chairman. I've been in coordination with KDH&E, and actually they approve of this amendment because they were already in the process of doing it, and I sent them the amendment, and they agreed to the language because they said it was broad enough to give them flexibility, but was a direction that they were already moving in, so they have no problem with us putting it in statute.
Thank you. Is there objection to this section? Representative, do you have an objection or a question?
Question, sir.
Go ahead.
With this particular section, in section 9, to the reviser or the bringer of the amendment, we're talking about scannable identification cards. We're coming into a time or a season of technology where it seems science fiction, but it's happening across the globe, where you can have implanted identifications, RFID microchips and such, being able to put all of your medical information and personal history information. Would any of that pertain to this?
Representative?
Thank you, Mr. Chairman. By my reading of this, this doesn't force people to get microchipped or anything like that. It says upon scanning or entering such identification card. So since identification card is used, my understanding is that that would be like something like your driver's license.
Representative, you have a question?
Yes, sir. Thank you, Mr. Chair. If the option, if, again, people are changing their technology and the way that they conduct business, not just on credit cards or IDs, but implantable IDs, does this give wiggle room for an individual to have an RFID microchip and all of this information downloaded on that RFID microchip? Thank you.
I guess I'll leave that to the reviser if I may.
Thank you. Reviser?
I would read the identification card language as requiring a physical card. It's kind of comparable to the discussion the committee had earlier this session dealing with the concealed carry permit license and the challenges that the Attorney General was having in issuing those because there was that requirement for a physical card. I would read the language as requiring a physical ID card.
Thank you, Matt. Any objection to this page 8?
I have a question.
Yes, go ahead, Representative Smith.
It's for the reviser. Matt, is there anything in the bill, I can't find it, but is there anything in the bill that determines a penalty for misuse of this card? In other words, somebody gets it from you and uses it themselves, you know, much like an ATM or a financial card. Is there anything in there that prohibits that or provides penalty for that?
Allow me a minute and I'll circle back with an answer on that.
Thank you.
Would that be agreeable? Thank you. Any objection to the section? Saying none. Go to the next page. Page 11. Representative?
Mr. Chairman, the copy that everybody has in front of them is now a little bit outdated because, as the revisor stated, after yesterday's meeting, Representative Epley and I, we married our two amendments together because we felt like it made it a more complete package, and we were basically doing the same function just a little bit differently. So mine is that instead of 12 months of you having to wait at a physician.
Would you they're going to hand this out.
Okay. All right. Fantastic. So anyway, this comes back to if I may ask the revisor one real quick question.
You may.
Thank you, Mr. Chairman. Matt, if I had a 20-year relationship with my physician, would that waive the 6-month requirement to wait? How this is currently written.
So the paragraph 2 requires that a physician who has a certificate to recommend may recommend that treatment for a patient if they have currently in the bill a 12-month relationship that has existed. So the amendment would change it to a 6 month. So if you have that existing 20-year relationship with a physician, you've satisfied that. You don't have to have a new 6 months added on. You have that existing relationship, physician-patient relationship.
Fantastic, thank you. So basically what this is doing is it's making it to where we're not making it a year, but if you're going to come in, you have to at least have a relationship of 6 months with the physician before you can be prescribed medical marijuana. And with the Epley Amendment included, that makes it to where you cannot also go out and doctor shop. So if one doctor tells you no, then you have to wait 6 months before going to another physician and trying to get medical marijuana at that new physician as well. So with this, if you already meet the requirements, you've already had that existing relationship with a physician and you're already getting medical marijuana, and say your physician retires, then at that point, your current physician can refer you to a new physician, and under this amendment, there would be no wait required because that new physician would give all the medical history over, and then the new physician would then do a medical examination on you to basically, okay, yes, this other physician is correct, I'll prescribe you medical marijuana. So that is the extent of what this does. If Representative Epley would like to backfill anything that I might have missed.
Thank you, and I think we now have a new amendment that was handed out, and would this be a substitute amendment for the language that are present in the Carpenter Amendment? Sorry.
Yes, Mr. Chairman.
Thank you. And you're both in agreement with this, my understanding, Representative?
Correct, Mr. Chairman.
So, when you make your motion, you're going to make a motion to replace the language that's in Carpenter 2 with the language that is what I've got marked and could be changed. On Epley 1, would that be correct? As to page 11.
Yes, page 11 should, with the information that was just handed out, it'll be replaced with that information, Mr. Chairman.
Thank you. Page 11 and page 12 would be replaced with the new amendment. Representative Epley, would you care to respond to this amendment?
Thank you, Mr. Chair. We did have discussions preliminarily yesterday, and it was obvious that these two amendments really should go together, and that's why we want to offer this replacement. It does allow for established patients to get a medical recommendation pretty quickly, right away, and it does have a safeguard that, if patients want accelerating amounts of THC, they have to wait 6 months before they choose another provider. I mean, I think that's sort of a floor, but I mean, it's a good place to be. That way it prevents doctor shopping to some extent, I think. So I think these two should go together, and that's why we put them together. Thank you.
Thank you.
Happy to answer questions.
Then when we take this up, was there other discussion? Yes, Representative Garber.
I have an objection.
Objections noted. We'll come back and we'll vote on this issue. Representative Woodard.
Thank you, Mr. Chair. My question just kind of has to go, it's not an objection, but with the 6 months for someone who is underinsured or not insured, doesn't have an established relationship with a physician, will they be, and maybe this is addressed in a different part of the bill, but will they be able to seek this medication from the county health department or safety net clinics, or how would that, does this impact any of that ability to seek the physician relationship?
I'll direct that to Representative Epley.
Thank you.
Thank you, Mr. Chair. The way I read this, and again, this is referring to Representative Carpenter's amendment, but is that you would have to be established with a provider/physician in this case for 6 months before you could have an indication or recommendation for THC.
My understanding is those that are underinsured or not insured
May not have a 6 months relationship, but the health department, they may. Would that be the exception here?
Well, to clarify, I mean, they can have a 6-month relationship with the public health department or free clinic or FQHC. They just have to have that 6-month waiting period. I've worked at the FQHC in our community, and we have patients that come there routinely and use it as their clinic, and it works out great. This just codifies that they would have to come in for 6 months first to really determine and prove that they have a need for THC going forward.
Thank you.
So it could be through that clinic or any clinic through a physician.
That eliminates my concern. Thank you, Mr. Chair.
Thank you. Other questions? Seeing none, we'll come back to this. Go to page 16. That be correct? This
Yes,
is,
Mr. Chairman.
Licensing?
Thank you, Mr. Chairman. So this is where we're going to, I think, have a lot of lively debate. And so I know there's going to be folks who object to this, so we'll definitely have to come back to it.
Well, want to go to page 22. Representative?
Thank you, Mr. Chairman. My understanding is that the top portions of this are referring to the previous amendment. Matt, or Revisor, no, it's not. Revisor, if you could help explain what's going on with the first two.
Thank you. Matt, if you would.
Yeah, so the first balloon references the third balloon. So those are really one item. The second balloon does reference what was done in terms of that ID card that's scannable. So that second balloon, just technical change. The other two taken together provide that ability for a county to prohibit the establishing of dispensaries in the county by adopting a resolution.
Representative, you wish to further elaborate?
Nope, that's exactly what it does. We still have dry counties here in the state of Kansas. I'm sure that there's some communities that will embrace this with open arms. There's others that I think our constituents will definitely not approve of. So this just gives the ability for those local communities to have control over whether or not a dispensary is in their communities or not.
Let me ask you, it says the Board of County Commissioners, so it's based upon a county resolution, not a city.
County resolution, yes, Mr. Chairman.
Thank you. Representative Wagner?
Yeah, I would have an objection. I think it's something we should discuss, just as far as broadening it beyond dispensaries. I mean, you would have counties would want to be out of the entire, network of cultivation and such.
I'll note an objection. We'll come back to it. Go to page 25.
Yeah, that's going to be a lot of discussion too, Mr. Chairman, so we'll have to come back to that and debate it. It's establishing, so right now it's establishing a certain amount of licenses for here in the state of Kansas. The reason why I did this was because currently in the bill, it leaves it up to rules and regs based on the population and leaving up to the director to spread those licenses out amongst the communities. There's 3 flavors of this right now. There's an amendment out there that has no caps on the licenses. There's the rules and regs right here in front of us, and then there's mine that actually puts it into statute, how many licenses will be let. And so I believe that this is approximately close to the appropriate amount of licenses that we should allow. but we'll have to have a lively debate on that.
Thank you. And I'm just looking at the clock as I normally do. I think we've made fairly good progress today. I'm going to go ahead and go to 29, page 29. Is there any objections to page 29, the Division of Alcoholic Beverage Control is hereby renamed the Division of Alcohol and Marijuana Control? Yes, Representative Garver.
Yes, thank you, Mr. Chairman. Since we're talking about medical marijuana, it probably should be medical marijuana control. That's only
Thank you.
oversight I have.
Very well. Well, when we get to this, to a vote, and a motion is made, you can always make a substitute motion to add medical marijuana, unless the two of you can get together prior to that and make an agreement.
I think that just having the overall marijuana, in my personal opinion, instead of medical marijuana, I understand it's in the rest of the bill this way, but in my personal opinion, AMC is better than AMMC, but that's just where I'm at, Mr. Chairman.
That should be a lively debate. Representative Garver?
My only concern is, and it's perception, when we talk about industrial hemp, people think marijuana. And ABC will not be in charge of industrial hemp. That's the Department of Ag. In the new amendments and my amendments, it takes the Department of Ag clear out of the medical marijuana field as they requested.
All right. Thank you. All right. I'm going to leave it here today. As I mentioned, I thought we made some fairly good progress. We may have another period to next week to hopefully either finish this up or not. I will ask for 2 days. I'll probably get one. And if we don't get it in the one, then we may look at it at a veto session or next year. And of course, next year I may have different committee members, and then I'll have new amendments. So hopefully, I'd rather do it with this group than a new group, but you never know. With that, we do have a couple of hearings tomorrow. I do anticipate working the Senate bill, which is a alcohol bill, which has amendments. I believe they've been agreed to amendments. It's indicated to me. If it wasn't for that, I would say you could watch by WebEx, but I would appreciate, if you're not going to be here, let me know. I'll get somebody appointed to sit in your chair for that purpose. But the only one we're going to work is, yes.
Mr. Chairman, I didn't mean to interrupt you, but I just want to clarify, we will not be doing any work on 2184 tomorrow.
That is correct. My intentions are to work the alcohol bill, do the 2 hearings, and then move on. So,
thank you, Mr. Chairman.
With that, thank you, committee. I guess we're on the floor at 11. We got a number of bills. We are adjourned.